Welcome. I'm Janae Nelson, President and Director Counsel of the Legal Defense Fund, also known as LDF. I'm so pleased to invite you into LDF's town hall discussion on the first 100 days of the second Trump presidency. We are officially 100 days in, and we knew going into this year, this administration, that the attacks on the rule of law would be significant. And the attempts to consolidate power would be far more aggressive than we saw in the first term. And as we expected, this first 100 days constituted a stress test on every system of government, on the American people, on civil society. But we also know that LDF was quite literally built for moments like this. In 1940, we were forged by Thurgood Marshall and a band of intrepid civil rights lawyers who wanted to create an institution that would lead this country in the fight for racial justice. And we have continued that mandate for the past 8.5 decades. And this moment is no different. We fought to force this country to live up to its constitutional ideals. We were able to, in the face of legal apartheid, force this country to replace that system, that inhumane and corrosive system, with one that lifts up the dignity and citizenship of all Americans. And we still have work to do. So, along with our partners in the civil rights field, we've been working in courts and state houses and Congress and city halls and so many other forums in tandem with the communities that we serve to ensure that we could eliminate racial disparities, that we could confront some of the assaults on our democracy head on. And we are continuing to do this in this moment in an unprecedented time. We are continuing our work to defend, to disrupt, and to dream. We will defend the rights and protections that we've secured. We will disrupt the machinery of authoritarianism, and we will continue to dream of a future for all of us that recognizes our innate humanity and ensures that we are protected by the rule of law. So it's fitting that we have today's conversation among the three of us, because it gives me an opportunity to introduce you to LDF's Associate Directors Council. To my left is Todd Cox. To my right is Sam Spatal. And together we lead LDF and have been doing the work to lead us through this very difficult moment, along with a formidable staff who continue to do what is some of the most challenging work that we've experienced as an organization. So I want to give each of our Associate Directors Council an opportunity to introduce themselves to you, and then I'm going to moderate a discussion among the three of us to answer some of the questions that you've already sent in and some that you may be sending in as we talk. So why don't I start with you, Todd? Why don't you introduce yourself, and perhaps you can also share a reflection on what these first 100 days have been like for you and for the work that you supervise.
Sure. Well, thank you, Janae. My name is Todd Cox, and I'm one of the Associate Director Counsels here at the Legal Defense Fund. I spent the past 30 years or so in the civil rights, human rights space, in philanthropy, in the Obama administration, at DOJ, and civil rights organizations like LDF and the Lawyers Committee. I'm grateful to be back at LDF. I can't think of another place I'd rather be in this moment in history. My reflection really goes to my ancestors, who I think migrated to Cincinnati, Ohio, fleeing an authoritarian government in Florida, Georgia, and Florida, family all over the Deep South. And I think about them when I think about this time period. This is an authoritarian government, and obviously the scale is much different, but they persevered. They were able to end up where we ended up, build a life, still confronting racism, but they persevered. And I think LDF was alive and functioning back then, and I think we're functioning now to sort of push back on this latest version of authoritarianism in this country. So that's what I really think about when I think about what we're confronting right now.
Well, thank you for anchoring us in that history. That's so important. I also draw on
Mm.
the history of my ancestors in moments like this. Sam, tell us who you are and your reflections on these 100 days.
Yeah, so thank you. Thank you, Janae, and thank you, Todd. My name is Sam Spatel. Along with Todd, I'm the Associate Director Counsel here at LDF and have the honor and privilege of working with Todd and with Janae under her leadership and with our incredible staff. And my reflection was similar to what Todd shared and thinking about it in terms of LDF and what Janae said at the beginning, that LDF as an institution was built for that moment and built for this moment. And I think we mean that in a really very specific way, that LDF was the principal legal organization involved in the civil rights movement, not only in the 1960s, but in the 1950s and the 1940s. And so as an institution, we did see the transformation of this country from what was in many parts of the country an authoritarian regime. And we were able to play a role in transforming that into a more genuine multiracial democracy, not one that has fulfilled the promises, but that at least was making some real progress. And we're in a moment now where we're seeing real challenges to that progress and to the basic premise of multiracial democracy. But I think we are able as an institution to draw on that history and to really be built for this moment.
That's absolutely right. We're in a moment of deep retrenchment, but we've seen that before. And in fact, we were, as you say, birthed at a moment when we were experiencing that in a high degree. So, Sam, I want to come back to you because you, before becoming Associate Director Counsel, and even still while Associate Director Counsel, have been overseeing our vast litigation docket.
Yeah.
And that is what LDF is primarily known for. Our countless Supreme Court wins, our incredible litigation prowess. So litigation has played a central role in the response to the assaults and what I would describe as a reign of terror in the past 100 days. Can you explain our work through litigation to push back and defend and disrupt under your leadership?
Yeah, absolutely. So already, just in these first 100 days, we have filed 5 new lawsuits just against the administration. And those lawsuits have addressed a number of the ways that the administration is trying to roll back the rule of law and really attack civil rights in a very fundamental way. Just last week, we secured 2 preliminary injunctions stopping 2 of the most significant ways that the administration was seeking to push back against progress to really sort of try to stop fundamental aspects of our multiracial democracy. And those 2 injunctions both were last week, as I said, on April 24th. One court held that an effort by the administration to require states to certify that they were following a new executive order, which is not a law, which is essentially President Trump just trying to declare what he thinks that the law should be, to stop that kind of executive order and then conduct taken by administrative agencies to implement the order, which would have prevented school districts from teaching truthful, accurate history, from having curriculum that actually described the history of this country, including the difficult parts of the history, including the history of anti-Black racism, of other forms of discrimination targeting marginalized communities, to try to prevent school districts from talking about that. And then also to try to prevent school districts from having fairness in admissions, having fairness in opportunities for all students to have full and fair educational opportunities in this country. So this was an effort by the administration that was about to be implemented. And at the last minute, because of a lawsuit that we filed on behalf of the National NAACP, a court held that they had to stop, that the administration had to stop what it was doing. On that very same day, in a lawsuit filed by us, along with a number of our partner civil rights organizations, including the ACLU, the Brennan Center for Justice, Latino Justice, and Asian Americans Advancing Justice, we were able to secure an injunction stopping the federal government from implementing a new voting executive order that would require people to show a passport or similar document in order to register for federal elections. A lot of people in this country don't have a passport or the kind of documentary proof of citizenship, that a lot of people don't have that kind of documentary evidence. And so there are other ways that you can swear and affirm your citizenship. And this rule, if it were implemented, could effectively prevent millions of people, disproportionately Black people and other people of color, from participating in our democracy. The federal court blocked that the same day as that other order I was talking about. So those are just two of the victories we've secured with respect to litigation against the federal administration. And the other thing I just want to talk about just very briefly is to note that the administration is not only attacking civil rights directly, it is also what they are doing to remove themselves from the historic role that the United States plays in enforcing civil rights.
Mhm.
And as a result of that, the LDF has to be a bit of a private Department of Justice where we have to step in and do the kinds of things that the Department of Justice should be doing. So in recent months, we have also been filing lawsuits trying to protect voting rights against a number of jurisdictions in states including Alabama, Tennessee, Mississippi. And that's the kind of work that we're also doing, and we're also having to do more of because of what we see at the federal level.
Wow, thanks so much for that overview. So last week was a real one-two
Yes,
punch.
yes.
And it's on top of all that state level work that you described, which has been work that we've been doing, for years. That's not new, but layered on that are these executive orders and other assaults from this administration. And just to put that in context, this administration, the second Trump administration, has issued a record number of executive orders. We're talking about, roughly 140 executive orders in 100 days. And we know that there have been many lawsuits, in addition to the many that we've brought. There have been, I think, upwards of 210 lawsuits challenging either executive orders or other actions from this administration, and more than half of the challenges have been successful in some way. So that's really important context to think about the power of challenges in the courts. But Todd, I want to shift to you because we also sometimes don't recognize the power of policy,
Yep.
right? And advocacy and engagement with elected officials. So Todd used to be the director of LDF's policy team years ago, and now has come back in this role as associate director counsel, and you've been overseeing our policy work. So please talk about how LDF has pushed back in addition to litigation, but through our policy arm.
Sure. Well, in this particular moment in history, we're looking at Congress being in some ways limited or limiting itself in engaging with this administration and providing a check. So what we've been doing at LDF is really raising our voice, raising our analytical chops, so to speak, to push back ourselves on legislation that's being introduced to curtail civil rights in this country. So a couple of examples. Sam mentioned the SAVE Act, or mentioned the documentary proof of citizenship. That is a key component of something called the SAVE Act, a requirement that you show provide this information upon registration, which would end the possibility for registration drives across the country. This act was introduced in Congress, but then quickly the administration issued an EO capturing that same information in the SAVE Act. And we sort of see that 1-2 punch with this administration working in concert with a supposed check against executive power. We're trying to work in concert to push along the finish line these horrible restrictions on civil rights. So we opposed that, did several kinds of strategies, or executed several kinds of strategies to make sure that we were opposing that bill. And so far, fingers crossed, we've managed to slow the progress in coalition with other folks in the civil rights community. We also, for one of the first times in our history, spoke out on the budget. This budget framework this president has put forward is draconian, to say the least. And while this administration has claimed to want to put America first, it really puts Americans last in many ways, and really is counter to the values of this country. And certainly, it's an anti-civil rights, anti-human rights bill construct, really taking swipes and reducing funding for housing programs that would enable all people, particularly poor and minority communities, to rent affordable housing. It takes a wide swipe at our education system, eliminating, in essence, Head Start, which would provide opportunities for low-income students to have an opportunity to engage in school in a meaningful way early on in their careers. In addition to being oppositional, however, we're also, as Janae alluded to before, dreaming a better world. And in doing that from a policy standpoint, we are supporting legislation that would restore Section 5 of the Voting Rights Act, which had been sort of gutted by the Supreme Court, as well as other features of Section 2 of the Voting Rights Act. And that bill is the John Lewis Voting Rights Enhancement Act. We were very active in supporting that bill and making sure that it remains a target for this Congress to push forward.
Todd, thank you so much. I'm so glad you introduced that concept of dreaming, because it's important that we're not just saying what we don't want, but
Right.
in this moment, we've got to put forth some examples of what actually will, A, prevent us from ever being in this position again, but is an affirmative vision for a multiracial democracy. So I'm glad you said that. I'm glad you were on the steps of the Capitol this Sunday to help talk about the budget and those critical issues. That was a sit-in on the steps of the Capitol, which shows you that our folks are not just, litigators and policy wonks, but we will do the activism work necessary in this moment as well.
That's right.
Now, Sam, you talked about the fact that we now have to be the private DOJ.
Yeah.
And that is a role that we know we're quite familiar with it, sadly, from the first administration. That was something that my predecessor, Charlene Eiffel, constantly reminded us of. What is different in this second administration is that we not only have to be the private DOJ, in some ways we have to be the private bar
Yeah.
as well, right? Because we know that the Trump administration has attacked quite directly, aggressively, and unlawfully many major law firms. And some of them have entered into agreements with the Trump administration, which may likely take them off the playing field when it comes to pushing back against its overreach and its aggressiveness. So can you talk a little bit about why LDF felt it was necessary to intervene and support and speak out against the attacks on the legal profession?
Absolutely. So it's so interesting because in some ways the attacks that we've seen on the legal profession are unprecedented. To have a president by name say, I'm mad at this particular law firm because I perceive certain members of the firm to be political opponents, and I'm going to impose these draconian measures to try to punish them. That is unprecedented. But what's not unprecedented is efforts by authoritarian regimes to attack lawyers. And when you think about the history to the initial conversation, during the civil rights movement, states that were seeking to defend Jim Crow, they often attacked lawyers, and including LDF lawyers or cooperating counsel were attacked, sometimes very directly, very personally, in very sort of harassing kind of ways. And so we know how attacks on lawyers are part of a fundamental attack on the rule of law, on our democratic institutions. And so when we saw how this administration has been very directly attacking law firms, we thought it was really important to file briefs in court talking about that history and emphasizing how patently unconstitutional what the administration is trying to do really is.
How do you prioritize, and how do we balance the work that pre-existed the Trump administration? Because to be clear, we were not satisfied with the status quo before January 20th.
Yeah.
So maybe, Todd, you can talk to how we're balancing pre-existing work with these new mandates and demands on our time and our resources.
Sure. I mean, I think the key is strategic planning, which is often a phrase that is unpleasant to think about, but it's key if you're going to be an effective human rights or civil rights organization. Because to your point, Janae, there's never enough resources, never enough time, never enough people to address all of the ills that confront our society and confront our stakeholders. So what LDF did before I came back was go through a very comprehensive, a very impactful strategic planning process. But when this election occurred and January 20th was looming, LDF decided to revisit that strategic plan. Not to upend it, but to really take a long, hard look at what was existing and what the world would look like now and into the future, and what that work might look like. I was part of those discussions, and we made some tough choices. Work that we were going to lead on, work that we were going to continue to work on, and work that we were going to have to just be supporting. And I think it's that kind of rigor and discipline that's required at these times, right? Because as Janae said, we had a full docket of desegregation cases, a full docket of voting rights cases, what I like to call our bread and butter.
Yeah.
On top of that, now we're challenging EOs. We're pushing back on an administration that's really overreaching in ways we haven't quite seen at this scale. And unfortunately, we don't have all of the existing checks and balances that we once relied upon to hold the executive and branch in check. So I think planning and discipline is really the call of the day. And also, I want to say integration, because I think many of the cases that Sam works on or oversees are the bread and butter cases that undergird the infrastructure that this administration is trying to undermine and take down. So you really need both the bread and butter cases, as I keep saying, as well as the sort of new attacks on that infrastructure in order to be impactful going forward.
No, that's absolutely right. And as you said, these are hard choices to make because all of the work feels urgent.
Yeah.
But some of the ways that we've been able to narrow it down is to look at what are some of the most direct attacks that go at the core of our constitutional principles and our democracy. And sadly, there's no shortage of them with this administration, but we have to pick and choose what's going to be the most important and significant area to push back on because it leads or bleeds into so many other areas of work. So Sam, I want to come back to you on something you talked about. We've talked about the idea of being the private Department of Justice, and there's an audience question here about how do we protect the rule of law given the positioning of DOJ.
Mm-hmm.
And it's easy to ask that question and just think, oh yeah, DOJ has been captured, but it's actually much worse than even the last administration that Trump led. And that is, there's been a whole upending of the Civil Rights Division.
Yeah.
There's been, as far as I understand it, about 480 attorneys who have left that division. We know that the voting rights section has abandoned many cases that it was pursuing. So it's not just that we can't rely on DOJ. We now have an affirmative, enemy in that department. Can you talk about how we are meeting that challenge when it's not just that we are, lacking a resource, but we now have an additional foe?
Yeah. It's a challenging a challenging moment to be in because I think it's not the world that we all thought about when we were going to law school, wanting to be civil rights lawyers, that we'd really be not only, as you said, not having DOJ as a partner, but often really having DOJ forcefully pushing in the other direction. And I think that to sort of go back to the theme about why LDF is uniquely positioned to address this moment that we're in, we do have our own set of, we have a docket, we have an existing docket, and we also have a history that we're able to draw upon where maybe we weren't necessarily seeing the Department of Justice as a direct foe in the same way, but we have this history of seeing what happens when governments that are supposed to be representing all of their people are actually not doing that and often targeting marginalized people within their states, communities, and in particular, the way that Black communities have so often in our history faced these kinds of challenges. And so we are able to draw upon the work that we have been doing, as Todd said, in desegregation cases, in voting cases, where we have long been on the other side of whether it's, the federal Department of Justice or sort of state level departments of justice. And so it's a playbook that in some ways we are familiar with, or at least able to draw upon those lessons and push back. And to give maybe a sort of discrete example, in a case, even though the federal Department of Justice had a more limited role, this term, for the third consecutive term, we were in the United States Supreme Court defending fair maps for Black voters. And it's because of the work that we have done with our incredible clients and our co-counsel, including the ACLU, that the 2024 elections, I think it is fair to say, took place, the congressional elections, for the fairest maps ever for Black voters in the South. And that was in part because of this extraordinary victory that we had in the Milligan case, where the Supreme Court, even this somewhat challenging Supreme Court, held that Alabama was discriminated against Black voters in the way that it drew districts, so Black voters didn't have a fair opportunity to elect candidates. And then we were able to build on that victory in this most recent cycle in Louisiana to create another district where Black voters would have a fair opportunity to elect candidates of choice. When that happened, though, there were a number of self-styled non-African American voters who were not happy about that. So they then brought a suit, and that has gone up to the U.S. Supreme Court. And shifting back to DOJ, so in the previous administration, the Department of Justice had filed an amicus brief, a friend of the court brief, that essentially explained why the positions of the civil rights groups in this case were the correct positions and consistent with the law. And then when the new administration came, they quickly said, oh no, that's no longer the United States. So, we're now in the position of having to show the court that we were right, we continue to be right, and the fact that the Department of Justice has switched sides or sort of taken away its previous position is of no moment really to the correct outcome of the case in the court. And that's the kind of example that we're seeing throughout litigation at the district court level, the appellate level, and in the Supreme Court as well.
Yeah, I'm so glad you raised that, because that's one of the things we're going to have to do even more as part of our strategy, and which is point out that the Department of Justice is not this objective
Absolutely.
arbiter of law, that
Yeah.
they have been captured, they've been politicized.
Yeah.
And that has to be clear to the judiciary. And we're seeing that the Supreme Court, certainly we can't predict every outcome, and some of the outcomes we can predict and we're very unhappy about,
Yeah.
what we suspect they will be.
Yeah.
But I want to just lift up what you said about the fact that we have been in the Supreme Court litigating historic voting rights cases for the past 3 terms.
Yeah.
Just earlier this year, we litigated this monumental case, and they all stem from this win that we received in Allen versus Milligan, nearly 70 years after Brown, right? We're still winning these landmark cases in the courts that spawned a redistricting revolution.
Yeah.
So that's important. Now, Todd, what people might counter and say is, that's great that you're winning these cases even before this Supreme Court. But what happens when a court order or a court decision is not respected or followed by this administration? And many people frame this as, a constitutional crisis, and we get that question all the time. Are we in one? Are we hurtling toward one?
Right.
I want to give you an opportunity to respond to that idea and what LDF's role is in responding to a constitutional crisis.
So, two different answers to that question. I think that whether or not we're in an official constitutional crisis, the very perception, the very fact that we're talking about it, puts us into a hugely problematic part of our history. I don't recall in my professional life questioning whether or not the executive branch would follow a court order. And dare I say, not speaking for the federal bench, I think they have not seen this either. And so I think we're at an inflection point.
That's right.
And I think what LDF can do is, and I've been famous with saying, with writing checks that my body doesn't have to cash. I don't litigate, but I think we need to continue to adhere to the rule of law, continue to call the question, continue to put in front of not only the courts, but the American people, our stakeholders, our clients, the fact that we do have norms.
Yeah.
That we do have a system that we've relied upon for 85 years to advance civil rights that has worked. And frankly, as I said, call the question and make others adhere to it. I think the federal bench to date has been doing a remarkable job in this very confusing, challenging time, holding this administration to account. I think that we're continuing to look to them to lift up civil rights and human rights. The other piece of this is that, and I think we all need to remember that these victories are victories in the context of how I look at least at the civil rights law and the courts. The courts and the civil rights movement have always been counter-majoritarian. Brown, if you had put it to a vote, would not have won. I think we were always relied on the courts to lift up those seen as most vulnerable in our communities, lift up those who the executive, whether it be a state or the national government, oppresses. And so I think we need to continue to look to courts and hold them out there as a neutral arbiter of these kinds of things. The last thing I'll say is it's critically important that we make sure we're actually connecting with folks on the ground, not only so that they will do or be educated about the issues that we consider important, but genuinely connect with them to understand what their needs are. And I think I'm very proud that LDF is building out and has built out an organizing arm that can do that. They partner with folks on the ground, not pretending to be part of the community, but to communicate to them what LDF is doing, to get a sense of what their needs are, and connect that to our litigation and to our advocacy, both in policy as well as litigation. And the last thing I'll say is another piece to helping folks understand the importance of the rule of law and whether or not we're in a constitutional crisis is research. And we have the Thurgood Marshall Institute, which is building out LDF's research arm to be able to deploy that kind of educational material and information to really bring folks along. And I'm confident that once all those pieces are put together, that even this administration will slow down and really take a breath and make sure that they are actually adhering to the rule of law, adhering to what courts order, and following the process that we've laid out for when you disagree with a court. So
No, that's absolutely right. I'm so glad you talked about the power of the people. We are proudly continuing our tradition of organizing and really trying to engage communities, starting with Black communities and other communities, to meet this moment, because we're looking to the courts to protect us, but we know that the courts are under assault.
that's right.
We know that a judge was just arrested and is now being penalized by the Wisconsin Supreme Court because of her role in responding to a exercise of authority by ICE that seemed to be unlawful. And so it is important that people create the conditions and the context to protect the courts, to protect judges, and that we speak out because they are under attack. And something I always like to emphasize is that the Supreme Court's decision granting immunity to President Trump, which I think is so dangerous, was wrong-headed and needs to be reversed. It doesn't apply to every actor in the federal government. So these folks who think that they can just defy court orders or engage in unlawful conduct with impunity will be sadly mistaken if they continue along those lines. But we need our courts to really hold strong. And so, Sam, we talked a little bit about some of the cases we're litigating. I wanted to go back to one. It was actually the first one that we responded to, one of the first executive orders that was issued in this second administration. It was the challenge to birthright citizenship.
Yeah.
And that's such a fundamental core guarantee of the 14th Amendment. And I know that there was no question. In fact, we had talked about it well before this administration came into being, that if this happens, we're going to be ready to challenge it. And we decided to co-counsel with the ACLU on this front. Can you talk about why this was such a no-brainer for us?
Yeah, absolutely. I think for a couple of reasons. One is sort of historical, and one kind of present day and very practical. Historically, and I think a lot of people don't realize this, so the Birthright Citizenship Clause is part of the 14th Amendment, one of the amendments that was enacted in the wake of the Civil War and during Reconstruction, which, among other things, promises equal protection under the law. So in some ways, it's the kind of the most fundamental, I would say, part of the Constitution. And the Birthright Citizenship Clause is a response to this notorious Supreme Court decision from the 1850s, Dred Scott, which declared that Black people in this country were not citizens, period. That Black citizens did not have, Black people in this country did not have basic citizenship right. And so what the Birthright Citizenship Clause does is it says that everyone who was born in the United States is a citizen. And this is such a fundamental principle of citizenship and of full sort of ability to participate in our multiracial democracy that this administration is now assaulting with an executive order that says, notwithstanding what the Constitution says, we're going to say that actually, no, there are a number of people who are born in this country who are not going to count as citizens, which is so inconsistent with the 14th Amendment, with the rule of law, because it's another example of the president we hear a lot of folks, some folks maybe who have not always been friends of civil rights talking about how you just got to follow the text. If you just follow the text of the Constitution, it is
Textualism.
completely clear that what the administration is trying to do to get around birthright citizenship is unconstitutional. And so that, I think, is one of the major reasons why it was so important for us to get involved. The other major reason is that the attack on birthright citizenship is, of course, part of a broader set of xenophobic attacks, attacks on immigrant communities. And those attacks are very connected to anti-Black racism. There's a strong intersection between the xenophobic attacks that we see and a longer even history of anti-Black racism in this country, which we've seen in very concrete ways, attacks on Haitian communities, for example. And so it's just essential for LDF to be standing up for these historical principles and also to be showing the ways in which these attacks on immigrant communities are fundamentally grounded in racism and very linked to a history of anti-Black racism in particular.
That's right. I think you just articulated so well how we prioritize, right? How we choose these cases. I mean, it's clear when I hear you describe it to anyone listening why we would get involved in this case to protect the 14th Amendment, to deal with an attempt to rewrite our Constitution, with the stroke of a pen from the Oval Office desk, but also the real world consequences for people today who are of different, citizenship status or immigration status. So thank you so much for explaining that. I think another corollary is the attack on Brown versus the Board of Education, right? The attack on public education, which at its core is an attack on equal protection.
That's right.
Right? Brown was rooted in animating the Equal Protection Clause of the 14th Amendment. And Todd, we've seen an executive order seeking to effectively dismantle the Department of Education. We've talked about the Dear Colleague letter. How do you connect this assault on Brown? We celebrated Brown just last year, 70 years of this, integrated society that we have. How do you draw a connection between some of these executive orders that attack different parts of the 14th Amendment and the attack on Brown?
So I think, attacking these isolated, what seem to be isolated aspects of civil rights law, with the Department of Education, birthright citizenship, really rolls up into an attack on Brown and an attack on the civil rights infrastructure. I mean, Brown and the analysis of it gave rise to the Civil Rights Act of 64, gave rise to the Voting Rights Act, gave rise to the Fair Housing Act. And so when you start picking away at that tapestry, pulling one thread, the hope for this administration is that eventually you'll pull the whole thing down without having directly to say that you're against Brown or against, even more importantly, the promise of Brown, which are all those statutes I raised, but also importantly, the aspects of what Brown promised regarding public education. You testified with the Help Committee and talked about their desire to dismantle the Department of Education, but really they have been for a while, and this administration is now sympathetic to it, wanting to dismantle the promise of Brown in terms of public education in general, shifting resources from public education to private schools, to enable people to basically leave the public school education regime, and a regime that actually benefits disproportionately people of color and poor people. And I think that really is what's at heart here. The other piece I will say is it's part of a larger attempt by this administration to shift resources away from the stakeholders we represent, and to frankly allow for them to be able to give tax cuts and tax breaks to those who are very wealthy already in this country. In some ways, it's classic. In other ways, it's nefarious, because in the process of doing that, they're going to be undermining the civil rights infrastructure that we've relied upon for decades in this country.
That's absolutely right. And it's almost kismet that the Q&A is beginning, and there's a question that actually dovetails perfectly from that. So I'm going to ask both of you to respond. And it's about the attack on universities, right? So it's not just the attack on K through 12 public education that we're experiencing. This attack on universities, which began with the SFFA versus Harvard versus UNC decision that led to this broad assault on diversity, equity, inclusion, and accessibility, which of course that case does not say anything about.
Right.
That case is a very narrow decision about a very specific admissions process at these two universities and any universities that have a similar process, but somehow it's been extrapolated, it's been weaponized by this administration, and not just this administration, but many of our private actors that are trying to undermine Brown and undermine the project of our multiracial democracy with this decision. What I think is interesting is historically, with pre-Brown, we started in higher education
That's right.
with integration cases there, right?
Mhm.
So higher education has always been, in the crosshairs.
Yeah.
Why are we seeing this assault on higher education, and how does that link up with the work that we're doing to preserve truth?
Mm.
Yeah.
Anybody, or I can jump in.
Okay.
I can jump in by saying it picks up on what Sam said before. It's a classic tool of authoritarianism. You attack not only the most vulnerable, but you attacked also what they would say are the elite elements of our society. But really, we know that what's happening with Harvard is happening across the country at every level of higher education. And what they're trying to do is attack independent thinking, independent thought, institutions that inspire people to challenge authority, which is okay in this country. It's what this country was founded on.
First
So,
Amendment.
First Amendment,
Yeah.
right? So it's a classic tool. The other thing I'll say is it's also a means to get at what you said before, erasing our history, right? It's the attack on the Smithsonian, and it's the attack on these institutions that preserve our history. And in so doing, you can rewrite history, rewrite your story, rewrite our story.
Mm-hmm.
And so it's so important to know our history, so important to preserve these institutions that allow for that debate to occur, and these institutions that protect what we all can agree is historical records of what has gone before.
Yeah.
That's right.
Yeah. So, just picking up on that, I think the way you also framed the question about how these things connect and how they connect to our work.
Mm.
There's a study that the Thurgood Marshall Institute, which I talked about before, did, which found that in the protests that occurred in the wake of the murders of George Floyd and Breonna Taylor, that Black protesters were much more likely to endure violence than non-Black protesters. And there's such a link here, I think, between this attack on the First Amendment and racial discrimination, attacks on immigrants communities, where there's this real effort to demonize protesters who are seen as the other in some way, compared to who the administration thinks is sort of at the core of the country. And so it's about, really, for LDF to highlight how these attacks on the First Amendment are linked. The attacks on the First Amendment, the attacks of freedom of expression, the attacks on anti-authoritarianism are really rooted and very deeply connected to racist attacks and to other attacks on marginalized communities.
That's right. It's all a part, and I think that that's one of the messaging tactics that we have countered, I think, quite effectively by showing that you can't divide these communities. It's not about immigrants. It's not about people of a particular religious background or whatever phobia or ism you might be most inclined to align against. All of it is connected. And our comms team, I think, has done an exceptional job at trying to, weave this together. And we try to also narrate that in some of our conversations. I want to go to another question. So there is a question about what partnership and collaboration looks like with our organization and other civil rights organizations. And I'm happy to begin the answer there. LDF has always been extraordinarily collaborative. It's one of the things that I'm so proud of. Not only do we ensure that we're working with other racial justice groups and civil rights organizations more broadly, we use our convening power to bring people together. In response to the SFFA decision, we created the Advancing Racial Equity Alliance, which has a broad swath of organizations that are part of this pushback against the distortion of that Supreme Court decision, SFFA. And so we are in alignment with so many other organizations to show a united front among people of different racial and ethnic backgrounds, with women-led groups, with the LGBTQ plus community. And that's been, I think, essential to building the degree of resistance that we need to this to this moment. We also do so much co-counseling
Yeah.
in our cases. So maybe Sam, you can talk about some of those co-counsel relationships, and maybe Todd, you can talk about some of our coalitional work in the policy space.
Yeah, absolutely. So, as you said, a number of the cases that we have brought against administration, we are co-counseling with other civil rights organizations. We've talked some about before: ACLU, Brennan Center, Latino Justice, Asian Americans, Advancing
Lambda Legal
Justice,
too.
Lambda Legal,
Mhm.
absolutely. And I think one of the things that is so important about that opportunity to co-counsel is that it also allows different organizations to bring areas of expertise that they have particular insight or experience in, and not to suggest that. I think one of the things that's special about LDF and a number of other civil rights organizations is that we do have expertise on multiple issues. But to give an example, in the birthright citizenship case and sort of other immigrants' rights issues that we have litigated over the years, one of the real unique contributions that LDF can make is to litigate the racial discrimination aspect of a policy that is targeting immigrants, immigrant communities. And we might be able to partner with an organization that may have more experience doing immigrants' rights work, but maybe not have as much experience litigating a racial discrimination issue. So, it's those kinds of partnerships that I think can really be the most successful in terms of pushing back against an authoritarian or discriminatory tactic, and also where we can, as co-counsel, be the most effective for our clients.
That's right. How we leverage each other's
Absolutely.
resources.
Yeah.
That's so important in this
Yeah.
moment.
Sure, and I think that plays out in policy space and also in the organizing space. I think this administration has taken divide and conquer to a whole new level, right?
Yes.
So we see whole chunks of civil society being chipped away, law firms divided amongst themselves about how they're going to respond to potential EOs, existing EOs attacking them, universities having different approaches to how they're being attacked. I'm proud to say the civil rights community has really held together. And I think the reason that is because I think from the very beginning, we've understood that it's really important for us to be good coalition partners to avoid the attempt to divide and conquer. We're members of the Leadership Conference on Civil and Human Rights. Janae, our leader here, sits on their board. I think we used to take that for granted. I think in some weird way this would always be the case, but given the capitulation, quite frankly, of many civil society actors, we can't take it for granted, and we've sort of reinforced, I think, our commitment to each other as civil rights organizations to make sure that we are fortified for this moment. I think also it happens on the ground. I think you mentioned our convening power. What we've done on the ground under the leadership of our organizers is convene folks within the Black community who may have different viewpoints, different opinions. That happens at the national level, certainly under your leadership with other legacy civil rights organizations. So I think organizing as well as coalition building across the African American diaspora, within it, outside of it, is something we're really fundamentally adept at, and it's really been core to our success. The last thing I'll say is it's also true and authentic to our communities.
That's right.
Black people, like everyone else, live at the intersections. I think we as organizations organize ourselves for funding reasons, for all kinds of reasons, in rather siloed ways. We have to work hard to break those silos, and it's important to do that because our clients, our stakeholders, don't exist in narrow silos. They exist across a wide variety of difference, and I think working in coalition helps us be authentic and true to that reality.
That's so right, Todd. And I love that you always remind us of the fact that we are standing shoulder to shoulder in a way that many other sectors aren't. And that's so critically important given the role that we play and what's expected of us, and how important it is for us to remain solid and unified if we're going to confront this threat and win. So Stephanie, I want to thank you for that question. That was a really good one. I'm going to take I think maybe one or two more questions. One is from Robert, and he asked about the issue of confronting this war on truth, which we've already touched on. But something else he asked was, what role can corporate entities play in this moment? And, that's a fraught one, right? Because we know that many corporations have, boasted about their retreat from diversity, equity, inclusion, accessibility, thinking it might win favor with this administration, thinking that, perhaps this was a dispensable set of principles.
Yeah.
The reality is that not only are diversity, equity, inclusion, and accessibility important values for most Americans when you explain what those values are, but they also affect the bottom line,
Yeah.
right? I mean, they're critical for innovation, they're critical for productivity, they're critical for pipelines of leadership, they're critical for global competition.
Yep.
And so when companies retreat, they are doing themselves a disservice, and they're doing a disservice to our multiracial democracy. So the role that corporate entities can play is, one, not to retreat, not to capitulate,
That's right.
and also to recognize your weakness. We do know of at least one major retailer who's reportedly losing millions of dollars
Right.
because customers are deciding to invest their money in corporations that believe in them and not
Right.
ones that are hostile to those principles. So I don't know if you have any other thoughts about the corporate landscape.
I'm old enough to remember the affirmative action litigation in the Supreme Court.
Mm-hmm.
We were successful as Legal Defense Fund in garnering a whole body of amicus briefs from companies, from the Department of Defense, all saying how important diversity was.
Yeah.
They weren't doing that because, no offense to corporations, they wanted a feel-good moment. They were doing it as a practical matter. I worked in the private sector. They knew that diversity was important for the bottom line. The world is diverse. Elite spaces are diverse. And the companies and entities that run away from that really are going to end up putting themselves at the end of the line when it comes to benefits, when it comes to profits. That's why it's disastrous what this administration is doing. I think the United States was a leader in making sure that we had a diverse workforce, a workforce that understood how to meet the needs of a wide variety of customers. By taking the action they're taking us backwards. And I have to say, it's going to end up hurting the bottom line for this country. The last thing I'll say is, when I was at the EEOC, we made it very clear. We had statistics, we had numbers, we had studies that showed that discrimination, having a discriminatory set of practices in a company really did hurt the bottom line, because you end up excluding people. You end up excluding people who probably were some of your best workers. And the much more open process for employment, for example, one that casts a wide net, assures you of it makes sure that you actually are touching upon every qualified person. So it's a no-brainer to me that you would, if you want to run a successful business, you have openness regarding diversity and inclusion.
Yeah.
That's right.
Yeah, well, I mean, the more positive side has been positive to see shareholders at some corporations voting down anti-diversity measures, and some corporations doing the opposite of the corporations that we've been quite rightly focused on. I think the only thing I would say is that the Supreme Court has made clear in some very controversial decisions that corporations have some serious legal rights in our society.
Yes.
And I think one of the things that's really important to remember in this moment is that means that the ways in which corporations maybe are being targeted by some of the anti-diversity measures, these anti-diversity efforts by the administration, they're not laws. Right. They are efforts by the administration to exert power that it does not have. And so corporations have rights to make clear that no, they're going to follow what the law is, right, not what the administration would like the law to be, or the pressure, that sometimes improper pressure that the administration may exert on corporations, just like the administration is seeking to exert on other actors in our society.
That's absolutely right. And Eugene asked this question about how we're holding corporations accountable. And I will just say that when corporations abandon diversity, equity, inclusion, and accessibility, they leave themselves open to lawsuits, right? Because often those are measures that help them stay on the right side of anti-discrimination laws and principles. And when you just sort of willy-nilly decide to take those programs away and take those principles away, you are likely, because of the pervasive discrimination and bias that still exists in the society, you're likely to find yourself in a compromised position when it comes to compliance with anti-discrimination laws. So listen, we could go on and on. These past 100 days have left us with no shortage of issues to talk about. But one, I want to just say thank you to both of you. I not only enjoy this conversation, I enjoy having you in this most challenging moment for our country. And what I want to close with is the fact that, we're counting these 100 days as an important marker for us to assess where we are, what our response has been. how we are meeting this moment and how we will continue to meet it for the next 100 and nearly 400 days left of this administration. But I'm more than that. Sorry, a multiplier of that. I'm wishful thinking. But I will say this: we need to look at this in the broader context of history and the long struggle for racial justice. So while we are 100 years into this, 100 again feels like dog years. 100 days into this administration. We are a mere 60 years into this multiracial democracy. If we think back to the passage of the Voting Rights Act of 1965, we are a mere 160 years from emancipation. And we are over 400 years into the fight for full Black freedom and liberation. So we are not new to this struggle. We recognize our place in the history and continuum of that fight, and we aren't going anywhere. We were built for this. We have been fighting. We will continue to use every resource and every tool at our disposal to push back against this authoritarian regime and to vindicate the rights that we've already secured and to create new ones, because our mandate is to defend, to disrupt, and continue to dream despite the assaults that we're facing. And we thank you so much for your support and for joining us in this conversation.